So today we will start discussion on the next group of the cyber offenses, that is obscenity and pornography. Here sections we will discuss, four sections of the Information Technology Act. One is obscenity, section 67 of the Information Technology Act. The second is the pornography, the pornographic material, section 66, section 67A, and child pornography, section 67B. And the fourth one would be bodily privacy, clicking of picture of the naked person in such a way that it would be the breach of the privacy. Maybe why this word breach of the privacy, like in the persons who are taking bath openly, maybe in the bikini on the beach. So that does not mean that some person if click the picture, that may be the privacy in that sense, but it would not be the breach of privacy in that meaning. Now here the first thing we will discuss is about the obscenity. And see, it's very difficult area. It's very not difficult in that sense that we cannot understand. Difficult in the sense that we have to think it very carefully, because the issue of obscenity has always been the complex one, as it involves the issues like decency and the morality. It's very difficult to judge the obscenity in the straitjacket formula or straitjacket principle. It needs to be the wider perspective. It has to be seen in the broader perspective. For example, the depiction of body form is indecent and vulgar for some, but for some it is the artistic expression. You will see the picture made by the M.F. Hussain, the woman, etc., and you will find that it is very obscene, but that may not be from the artistic point of view. Section 67 have the marginal note, and that talk about the obscenity, it's saying, and it has the same language as used in the section 292 of the Indian Penal Code. In the section 292 of the Indian Penal Code, the language used that any material like book, pamphlet, writing, etc., drawing, having would be deemed as obscene if it is lascivious or appeal to prurient interest, or if it affect where it comprises two or more distinct items, the effect of any of them is taken as a whole, such as tend to deprave or corrupt the persons who are likely having regard to the relevant circumstances. And these three phrases are actually used to define that what is obscenity. Okay. Similarly, under the section 67 of the IT Act, you will find that whoever publishes, what is publishes? That means making a electronic material available for the public. When you put a material that is approachable by two or more than two persons, maybe that is closed group or that is open for all, it would be publication. It's not, the argument should not be taken that it was only the small group of 5-6 persons or 100 persons. Whoever publishes or transmit. Transmit means when you send that electronic record from one person to the another persons. So the difference between publishing and the transmitting is that the transmission is between two persons, it's private, and the publication means the act by which that material is available to the public, that means two or more than two persons. Or causes to be published or transmitted in the electronic form. Causes to be published means maybe through the automated means you have installed by which it is published, or maybe as an abater you have abated, you have helped other persons to make it published. in electronic form, and this electronic form is only difference from the section 292. Any material which is lascivious, the first lascivious, second appeal to the prurient interest, or third is if its effects are such that it tend to deprave or corrupt the persons who are likely having regard to all the relevant circumstances to read, see or hear the matter contained or embodied in it. And then there is the punishment. The punishment here for the publishing or transmitting obscene material is that on the first conviction with imprisonment of either description, if you talk about section 53 of the Indian Penal Code, hard, that is rigorous imprisonment, that is hard labor, and simple imprisonment. So it can be of both, may extend to 3 years, up to 3 years, okay, and with fine which may extend to 5 lakh rupees. So it's not that or fine, punishment and fine, punishment up to 3 years of either description, fine up to 5 lakh, and in second or the subsequent, like in the second conviction or later on third conviction, fourth conviction, imprisonment of either description which may extend to now from 3 years to 5 years, this extended punishment. So sometime student ask that why it has to be shown. First, the conviction has to be made on the obscenity. Then when the conviction is made, then at the time of the quantum of the punishment, the earlier conviction has to be shown. Only then cause of action arises. So here is the enhancement of the punishment, like we discuss under section 75 of the Indian Penal Code, enhancement of punishment. In case of theft, the normal punishment under section 379 is up to 3 years, but it may extend to imprisonment for life for the enhancement of punishment. So herely, after a person is convicted as obscene, at the time of the quantum of the punishment, if first conviction is shown, then the punishment may be up to 5 years or fine which may extend to 10 lakh rupees. So from 5 to 10 lakh rupees can be extended. Now what is this obscenity? What is this lascivious or prurient interest, or if it fall into the persons have tend to deprave or corrupt the mind, what is this? So this, all these things is talking about the obscenity. And here the obscenity at one side, when there is the allegation on a particular literature or a particular artistic work that it is obscene, if we decide slightly in favor of that material that yes it is obscene without even thinking minutely, that particular act would be an offense, and that means the persons who made this act is depriving his right of freedom of speech and expression. So there are two conflicting rights. One is the freedom of speech and expression, and other side there is the decency and morality. And so article 19(1)(a) freedom of speech and expression have the reasonable restriction under article 19(2). In different words are used there, and there is the decency or morality. The justification between section 292 or section 67 of the IPC, that these provisions are having the reasonable restriction on the freedom of speech and expression in decency and morality, because what is obscene is the against the decency, against the morality. Now what is an obscene material? It's really very difficult, and it depends from the society to society and from time to time. What may be obscene in India may not be obscene in America or Canada or any European country, and what is not obscene in India may be obscene in the Muslim world. What is obscene now may not be obscene after 10 or 20 years. So it depends with the community, it depends with the time. And here we have to discuss that obscenity with respect to the different jurisdictions. The earliest test laid down on the obscenity was in the case of Regina versus Hicklin in Britain, and the judgment delivered by Lord C.J. Cockburn. And this judgment or this particular test that is laid down in Regina versus Hicklin is popularly known as the Hicklin test on the obscenity. Here it was held that if a material that is in the question, that whether that material is obscene or not, that is lascivious or appeal to the prurient interest or not, has to see that whether that material has the tendency to deprave and correct those whose minds are open to such immoral influences and whose hand a publication of this sort may fall. So, any persons who, because he is hypersensitive or because he is of very tender age, and in that persons if this type of the material fall, that persons you know have the lascivious feeling, then it would be obscene material. In the Hicklin opinion, Lord C.J. Cockburn said that the danger of the prurient literature was that it would suggest to the young of either sex or even the person of more advanced years thought most impure and libidinous character. But there is drawback with respect to this test. This test is say that whether a particular material is obscene or not, we have to see from the eyes of the person whose mind is open for such moral influence, and imaginarily in whose hand such type of the publication would fall, what would be his reaction if that person whose mind is open for such immoral influence, if that person would deprave or corrupt, then it would be obscene material. And this was very hard test because it's taking into the consideration of the persons whose mind is open. It's not talking about the reasonable person, etc. Then at the another jurisdictions in the America, in 1873 Comstock law was passed, and after that the in America the first case on the obscenity was United States versus one book entitled Ulias. In this case, the Supreme Court got the opportunity to determine, to lay down the test with respect to the obscenity, because it's always difficult questions. People write the novel, people write the other literatures, theater, drama, movies, pictures, etc. And it's always difficult to term them as an obscene and to stop them or to allow them. And so in the 1957, in the 1934 United States, not 1957, 1934 United States versus one book entitled Ulias, the US Supreme Court held that the criteria for obscenity was not to see the content in the isolated, rather it has to be seen as a whole, whether the publication as a whole has that lascivious nature, has that prurient interest, targeted to prurient interest, or tend to deprave or corrupt the person. So what the in the Hicklin test, that we have to see the individual things with the tendency to deprave and corrupt, whose minds are open to such immoral influence and in whose hand the publication of this sort may fall. Slight changes is made in 1937 in the US jurisdiction, that US Supreme Court in United States versus one book entitled Ulia says that we have not to see only those paras that are in the contention, that thing that is there is in the allegation, but the whole material, the whole publication. If you see the murder movie, there are many scenes, the intimate scenes between Imran Hasmi and the actress. But if you see the movie as a whole, it was not targeted to the prurient interest, it was not lascivious, rather it's showing the the feeling, or you can say the confusion of the married woman who has earlier boyfriend, etc. So the main target of the movie was not in that direction. So this slight change happened. Then again American Supreme Court in 1957 got opportunity again to define that what is obscenity in Roth versus United States. And there in the Roth versus United States, the drastic change or the major change happened, that if we see the material from the persons whose mind is open for this type of influence, that hypersensitive person or that tender age person, then many material will be obscene. So we have to see from the eyes of the average person. And ये कौन सा एवरेज पर्सन होगा? The average person of the community in which that publication is done. So the community standard, the average person applying the community standard, the dominant theme of the material taken as a whole. So the first test, the first time in the United States versus one book entitled Ulias, वहाँ का जो phrase था that as a whole also included in this, and now it became that the material has to be seen from the eyes of average person applying the community standard, the average person of the community in which this publication was done. And the dominant theme of the material, the whole material has to be seen, and that the whole material from the eyes of the average person in the society in which it is published. If it is targeted to the prurient interest, if it is lascivious, that means the person is depraved or corrupt, having thinking about the very impure, libidinous, sexual nature, the carnal pleasure only, then that would be obscene material. Then later on again the refinement happened in the obscenity test, because America is very advanced in developing the legal jurisprudence on many aspects. So in 1973 in Miller versus California judgment, the US Supreme Court declared that state might prohibit the printing of, because there is the federal structures, the state Supreme Court, the central Supreme Court, state have their own judiciaries, center have its own judiciary. So the work which appealed to the prurient interest in sex, which portrayed the sexual conduct in a patently offensive way, and which taken as a whole do not have the very serious literary, artistic, political and scientific value. So further this test has been laid down, that if a particular material is showing the or depicting the sex in patently offensive way, even if showing the intimacy between husband and wife and boyfriend and girlfriend, if it's important even to showing that much of intimacy by the kissing scene, etc., so that would also not be the obscenity. But showing the the sexual act in very patently offensive way would be. And another thing added, that the material also have to seen that whether it is having some artistic, literary, political or scientific value, or it is lack of, devoid of these value. If the material is devoid of any literary, artistic, political value or scientific value, then that would also be obscene material. So, within 1973 in the America, the standard was that Miller versus California, that three things has to be seen. So, these three things came from both earlier judgment also. The first one is that whether the average, if there is a question on a particular the passage or the particular material, that it is obscene. So, that material has to be seen with the eyes of the average persons of the community in which it is published, the average person applying the community standard, contemporary community standard, community भी उसी टाइम के, ऐसे नहीं पुराने community के, and to find out that the work as a whole is appeal to the prurient interest, lascivious, or it tend to deprave or corrupt the mind of the person who are likely to. Or the second, that whether the work depict or describe in a way patently offensive way the sexual conduct. Or the third, whether the work taken as a whole is devoid of literary, artistic, political or scientific value. So, with these three parameters, the obscenity has to be determined. And if we compare this test, the Roth and Miller test, with respect to the Hicklin test, there is so much change is there. There in the Hicklin test, individual paragraph has to be seen, individual material has to be seen, and then that has to be seen with the eyes of the person whose mind is open for such immoral influence. 14 साल 15 साल के बच्चे के आइज से देखो. So that was very strict test with respect to the obscenity having unreasonable effect on freedom of speech and expression. Later on in the 1987 in Supreme Court, in the Supreme Court of the United States, another case came, Pope versus Illinois. And here in the Pope versus Illinois, the court said that the proper inquiry was not whether an ordinary member of any given community find the serious value in the alleged obscene material, but whether a reasonable person would find such value or taken as a whole. So, from the average persons, the standard became the reasonable person. As a law student, you must be aware about this phrase as a reasonable person, many times it is used. And you always confuse that who is this reasonable person. It's always, if I speak frankly, it's always judge, and judge has to think, and that's why judgment differ from person to person. Because if you see the realistic school of jurisprudence, the judge's background, their upbringing, their understanding depend the quality, the judgment, how they will deliver, how they think, and that ultimately even have some contribution in redefining the law. So now from after this of Miller in this Pope versus Illinois judgment, with the average persons, that means the reasonable persons applying the community standard, taking as a whole, we have to see that whether that particular matter is targeted to the or is appeal to the prurient interest or lascivious or tend to deprave or corrupt the mind whose mind is likely to be. Okay. Now, with this obscenity test in America and UK, now come to the India. In India, after independence in 1965, our Supreme Court got the first opportunity to define that a particular material is obscene or not. And there also it was also argued that section 292 itself is unconstitutional, because it have the effect it unreasonably restrict the freedom of speech and expression. The Ranjit Udesi case 1965, the Supreme Court of the India, and because we follow generally the you know English law, so here our Supreme Court observed that the test of the obscenity laid down by Cockburn, Chief Justice in Hicklin test should not be discarded. It held that the test of obscenity adopted in India is that obscenity without prepondering social purpose, obscenity without having any social purpose or profit, cannot have the constitutional protection of the freedom of speech and expression, and the obscenity in treating sex in a manner appealing to the carnal side of human nature and having that tendency, the obscene matter in a book must be considered itself and separately to find out that whether it is so gross or its obscenity so decided that it is likely to deprave and corrupt those whose minds are open to the influence of this sort, in whose hand the books likely to fall. And here the Supreme Court has adopted the test laid down in the Regina versus Hicklin or the Hicklin test. But there was then the change. This change was in the 1986. In 1986, when our Supreme Court got again the opportunity to decide, to determine whether a particular material is obscene or not, in the Samres Bose versus Amal Mitra. And in Samres Bose versus Amal Mitra, the Supreme Court has said that there is difference between the vulgarity and the obscenity. A vulgar writing is not necessarily obscene. Vulgarity arouses the feeling of disgust and revulsion and also boredom, but does not have the effect of depraving, debasing, or corrupting the moral of any readers of the novel, wherein obscenity has the tendency to deprave and corrupt those whose minds are open to such moral influence. And so the vulgarity, you see many movies, like if you have this Mirzapur or many other movies that is available on the different OTT platform, you will find so much vulgarity is there, so much filthy language is used there. But that does not suggest, or that does not having the the effect that the person will think about the carnal side, think about the sex. It's showing the disgusting language, if the abusive language is used there. So here certain development started from this period about narrowing down the obscenity, and then in 2006 Supreme Court of the India have expressly endorsed the judgment laid down into the Miller. So we have the paradigm shift from the Hicklin test to the Miller test, and in this judgment the name of the case is Director General of the Doordarshan versus Anand Patwardhan. Here the Honorable Supreme Court has endorsed the Miller test, clearly here endorsed the Miller test. So all that with the average person supplying the community standard and seeing the material as a whole, if it is targeted to the prurient interest or lascivious or have the tendency to deprave or corrupt the mind, and it's showing the sexual act in the patently offensive way and even devoid of any literary, artistic and political or scientific value, then that material would be obscene material. So with 2006 our Supreme Court has have the same test of the obscenity like in the America. Then in next year in 2007 in the Ajay Goswami versus Union of India, the court has observed that the test of judging a work should be that of an ordinary man of the common sense and prudence, and not that out of ordinary or hypersensitive person. So here again, if you remember Pope versus Illunius, that's reasonable persons. So reasonable persons तो नहीं बोला, but the ordinary persons, not the average persons. From average persons, the word used in the Miller test, that endorsed by the Supreme Court in Directorate General of Doordarshan versus Amit Patwardhan, to the ordinary persons, that nearly to the reasonable person, not the hypersensitive persons. Maybe some persons see picture in the Times of India newspaper और उनके मुंह से निकलता बस सृष्टि विनाश हो गई, भौर गंध मची हुई, so much obscenity. So it's not from the eyes of that persons. Average persons, maybe the average persons mean, how you will find out that average persons mean average person. Here the ordinary persons, maybe that person is hypersensitive. Okay, and so now we have the same standard with respect to that. And with that, the test of obscenity, to determine the obscenity in India as par with the America, that is the Miller test. Average persons replaced with the common or ordinary man, applying the community standard, contemporary communist standard as a whole, if the material is lascivious or appeal to the prudent interest, or is tend to deprave or corrupt the persons whose mind is likely, and if having showing the sex in very patently offensive way, or devoid of any literary, artistic or political and scientific value, then that material would be obscene material. Now in 2017, the Supreme Court of India again got the opportunity to define how to determine that a material, a particular literary or artistic work is obscene or not. And this case is in our case material. So here we will discuss this case. See, just give me 1 second. There is this magazine, Stern, and in this magazine there was the picture published, the picture of the famous tennis star Boris Becker, and Boris Becker standing along with his girlfriend Barbara Feltus, and this picture was clicked by the father of Barbara Feltus, and in this picture both are standing nude against each other. The breast of woman is not visible, they are standing in such a position, and the title of this picture, because the Boris Becker was white skinned person, and Barbara Feltus was black skinned woman. So there was this practice of apartheid between against the black persons, and this picture was to showing that how intimate relationship Mr. Boris Becker have the Barbara Feltus. Two persons with the different skin also have the intimate relationship, can be very happy, and this picture was published in the German magazine named Stern, and there the article picture Boris Becker as a strident protester of the pernicious practice of apartheid. So it was written this, okay, that love triumphed, the hates. So this was the message. The message this sports person was to give, that stop apartheid, stop hating the people on the skin color. They also think like us. They also, even have the same emotion, etc. When this picture was published in the Stern magazine, it was not controversy. The controversy started when This article was reproduced in the Sports World, a widely circulated magazine in India. And in the Sports World, this this picture was reproduced. This article was reproduced with the cover story in 1993, and the caption that's showing that posing nude, dropping out tournament, battling racism in Germany, Boris Becker explained his recent approach to the life. Boris Becker Unmasked. Then the another publication was in the Anand Bazaar Patrika, a newspaper have wide circulation in Kolkata and also published in the second page. The newspaper above mentioned photograph as well as the article as appeared in the Sports World. So, in the Sports World and in the Anand Bazaar Patrika, this picture of the Boris Becker with his girlfriend was published, the same as it was in the Stern magazine, the reproduction. And here Mr. Avik Sarkar, the lawyer, was practicing in the Alipur Judge Court, Kolkata, and he was the regular reader of these two, this magazine, Sports World and the Anand Bazaar Patrika, this newspaper. And he was aggrieved. He thought that, oh, society में तो पूरा obscenity फैली हुई है. And as a crusader, he wanted to take the actions, so he flipped the pages of the Indian Penal Code and found, oh, section 292, great relief. He thought about, and then he filed the complaint. Cognizable, non-cognizable hota na. So in cognizable cases, we filed FIR. In non-cognizable cases, we filed complaint. So he filed the complaint before the magistrate, and then complaint was examined. He was the witness was examined. Then the summon was sent. Then the magistrate, after holding, held that the persons examined under section 251 order and to put the trial of the offence of section 292. Okay. Now the question is before you, because I have explained many things. Now you have to decide, you have to think that whether this picture where Mr. Boris Becker, a famous tennis player, is shown with his girlfriend, both are both are naked and opposing each other. Even woman breast is not visible. So whether this picture is obscene or not obscene. Yes. Yes, Deepak?
So sorry to interrupt you. We have another class and ma'am has joined the lecture.
अच्छा, another class हो भी गई आपकी? Okay, just then give me 5 minutes, okay? Okay, or should we discuss this case next in the class, next class?
It would be better if we discuss it in the next class, sir.
Okay, so you keep thinking that whether this
Yes, sir. I concur.
whether this picture is obscene or not, taking into the mind that up to 2007 Ajay Goswami versus Union of India, we have the same standard on the 3 line, that whether as an ordinary person in the community, applying community standard as a whole, the picture as a whole with this caption is targeted to the prurient interest or lascivious or tend to deprave or corrupt the mind, whose mind is likely to, or it depicting the sex in very patently offensive way, or it's lacking of any literary, artistic or political and scientific value. So please keep thinking about it. In next class I need answer from you, and then I will discuss this case, the facts I have told you. Okay, and this case is very important. Every time question is asked from this point, so be ready for that. I stop here. Bye bye.